Welcome to Ms. Romanato, Mr. Maloney. Welcome to our committee. I know you're, and Senator Smith.
Yes.
Yes, welcome.
Sorry.
Although you're new, it may seem daunting in terms of the length of time we've all been hearing evidence and discussing these issues. These are important issues. So some of the takeaways that I want to highlight first, I certainly will try not to repeat the comments of my colleague, Mr. Motz, but we are also desirous of coming to a conclusion sooner than later. And I believe there is a path forward to do that by the end of this session, sometime in June. But we never anticipated that when this particular committee began its examination of the invocation of the act and the circumstances surrounding it, while we heard rumors that there might be a charter challenge, we didn't know to what extent that would look like. We didn't know what the results would be, but we certainly had that at the back of our minds moving forward. And I also want to highlight on the issue of witnesses. Back in December of 2022, with a tie vote, and in this particular committee, a tie vote results in a negative passing of a particular motion, and a motion was brought by the Conservative team to extend the study, to call further witnesses that we deemed would provide relevant information, and the vote was 5-5. So by no means did that vote indicate a strong majority preference, in my view, to shut down the possibility of hearing from further witnesses. We lived by that decision, and we then instructed the analysts to prepare a review of the material and provide us with draft reports. We are now in draft version number 3. In that time frame, we had the Rulo Commission, and I want to highlight that there's, although it's statutorily mandated that a commission launch during the invocation of an act or following the invocation of the Emergencies Act, and although it was presided by a justice, a Superior Court justice, the mandate of Justice Rulo was not to provide any charter analysis of the legality behind the invocation of the act. That legal mandate did not exist. And I think in his wisdom, Justice Rulo definitely shied away from making legal pronouncements because he knew ultimately this was a matter that was going to be studied and argued in the federal court. At that point, 2 institutions, as outlined in our particular motion, had launched a charter challenge, that being the Canadian Civil Liberties Association and the Canadian Constitution Foundation. So Justice Rulo, as my colleague has indicated, in his opening remarks and in the report itself, makes it abundantly clear that the evidence was by no means overwhelming to him to conclude that there was a legal justification by the Liberal government in invoking the act with the circumstances that presented itself primarily in downtown Ottawa and secondarily with respect to some of the border crossings in Alberta and here in Ontario at Windsor. He made it clear that reasonable people who had the ability to review all the evidence that he heard could come to a completely different conclusion than he did. And I highlight that phrase, evidence. And this segues to the concern that our Francophone members have on this committee, that the submissions and the evidence heard at the Rulo Commission was not translated in the other official language, which has compromised the constitutional right that all members have in this House and in the Senate to receive information in both official languages. Now, we are certainly not suggesting, and the motion was drafted in such a way that we don't want every single piece of material or submissions officially translated into the other official language. It would take years to do that, and I think we received a figure in terms of the cost analysis, well over $300 million. And at one point, this committee said, well, you know, that sounds like a daunting task, and given the financial crisis that we have in this country and the affordability issues, and many families, thousands of families, literally one paycheck away from insolvency, we have to be prudent stewards of the taxpayer money. So that, in my opinion, would not be a proper exercise of our authority. We talked about perhaps just getting translated the index, an index indicating how the arguments were presented so we can identify who said what, and maybe the index of the exhibits, 2,500 potential exhibits. But again, that price tag was $5 or $6 million, another extraordinary expense that cannot be justified under any circumstances. So the motion is drafted as such that we can hear from individuals to perhaps give us the answers that we seek without going through the expense. And I think, I can't speak for my colleague and chair, Monsieur Fortin, but I can speak on behalf of Senator Carignan, and he's certainly on the speaking list, and I don't want to take away his submissions, but I think that was a reasonable compromise. So I appreciate, Ms. Romanato, your approach. I think we're not too far off in terms of where we both see a pathway to proceed with, but I think it's incumbent on us as parliamentarians and senators to give value to Canadians. This was an extraordinary time in this country during the pandemic, and the response to the pandemic by the convoy and the supporters of the convoy that descended here in Ottawa. But I think it's a reminder to us all that we are a country of law. We are a country of order. And we don't interpret the laws to fit what we believe as a government, a narrative that's not supported and grounded by facts and not supported and grounded by the legislation. The legislation in the Emergencies Act was abundantly clear. It could not be more clearer that the definition of a national emergency is the same definition as defined under the CSIS Act. It did not say anywhere, or as other interpretations may be available, or as other circumstances may be available. The law was black and white. It wasn't gray. And that's what we expect. That's what we expect in this country. We, as drafters of legislation, use our best skills and resources to provide clarity with the law. Sometimes we get it right, sometimes we get it wrong, and courts and appeal courts and ultimately the Supreme Court of Canada will weigh in if we do get it wrong. But in this particular case, as my colleague Mr. Motz has indicated, we heard from Perrin Beatty, who was a cabinet minister, who was primarily the architect of the Emergencies Act. And as we all know, the Emergencies Act was designed to replace the War Measures Act, which has significant flaws in terms of trouncing on the civil liberties of Canadians. And there was a mandate to do better. It was a mandate that we would create the most strongest, the most powerful law available to a national government in times of true national emergencies. Now, through resources that may not be wholly available to this committee, I've certainly been privy to resources from the government itself, that there was even a consideration of the invocation of the Emergencies Act at the outset of the pandemic. Frightening, disturbing on so many levels. Then we had evidence very early on from ministers such as Mendicino and Lametti, the most powerful legislator, lawyer in this country, jokingly opining with Mendicino on day 2 of the convoy, let's bring in the tanks. Appalling. It was a joke, but it was an appalling remark. I have defended, and I will defend with my last breath as a member of the Law Society of Ontario, the Charter of Rights and Freedoms. And while the Charter of Rights and Freedom is drafted in such a way that these are not absolute rights, they are enshrined rights, and they are valued rights. The right to freedom of expression, the right to peaceful assembly, the right to be secure against unreasonable search and seizure. All of which ultimately came to a head with this Liberal government when they determined that, notwithstanding that the City of Ottawa Police Service, as well as the City of Ottawa municipal government, directed the convoy truckers to park on Wellington Street, directed that there be a off-site location for the supply of materials to run back and forth. All of this was planned. It was organized. There was discussion between legal authorities and the truckers. One thing that no witness has ever been able to answer, and I asked this, if I asked it a half a dozen times, I probably asked it 24 times. At what point in time and at what event did this lawful exercise of the freedom of expression and assembly, as directed by legal authorities, become unlawful? No one could answer that. The only thing I could surmise is that it became inconvenient to the government. It was certainly inconvenient to citizens in downtown Ottawa. The smell of diesel, the noise, the commotion. But in Justice Mosley's words, that's not a national emergency. That's what protests are. Protests can be loud. They can be uncomfortable. They can be a nuisance. But it doesn't rise to the high legal threshold of a national emergency. Now, all I ever heard, as well as parliamentarians and Canadians, is that this was required, that lawful legal measures was simply incapable of dealing appropriately with the removal of this blockade. And there's contradictory evidence, and I'm not going to get into that. The evidence is already on the table on that issue. But more importantly, what we heard from the Prime Minister to Marco Mendicino and David Lametti and Minister Freeland and Minister Blair and probably the entire cabinet bench was this was necessary, this was lawful, and we had legal justification. It was charter compliant. When we asked for evidence of charter compliance, oh, you can't have that. That's protected by cabinet confidentiality. Or you can't have that, Mr. Brock. That's protected by solicitor and client privilege. But the Prime Minister had no problems waiving privilege, had no problems waiving confidentiality with Justice Rulo, save and except that legal opinion that they received from the Department of Justice, which would have laid out under what legal authority do you have as a Prime Minister in government to invoke that act. They would not share that even to Justice Rulo. And I remember this exchange because I watched it live and I read the transcript after we heard the in-chief testimony of David Lametti, former Justice Minister, and the cross-examination, as judges often do and are entitled to do. They question the witnesses. And Justice Rulo did that. And Justice Rulo, I'm not quoting word for word here, but essentially said, well, you're not going to give us the legal opinion that justified your use of the Invocation Act. Am I to take from that, I'm just simply have to accept your opinion that it provided you with the illegal authority? And David Lametti said, yes, take my opinion. He could be right, but he also could be wrong. And I think it's important that we have access to that legal opinion, which is why we set it out in the notice of motion. And I think long term, because ultimately the government has telegraphed, like literally within minutes, telegraphed an intention to appeal Justice Mosley's decision, a very senior justice appointed by a Liberal Prime Minister, I might add, a very senior justice of the federal court. Other significant decisions that we have heard that impact the lives of Canadians, well, we're going to take it under advisement. We're going to examine all the circumstances behind the decision and weigh our options before we consider an appeal or not to appeal. But not this. Literally a jackrabbit response. He got it wrong. We heard that from our new Justice Minister. He committed judicial errors. I'm sure at that point our Justice Minister didn't even read the full decision. It was a very lengthy decision. And I would be surprised if he had the time to read the decision in full before he quickly pronounced all the judicial errors that Justice Mosley made in his decision. But this again was parroted by the Deputy Prime Minister and many other ministers. There are justifiable legal errors that we can appeal. Now, I'm saying this because ultimately, if they hold true to their word and they will appeal this decision, ultimately the appellate court, wherever that may be, the Federal Court of Appeal, maybe ultimately the Supreme Court of Canada, is ultimately going to hear from Department of Justice lawyers as to what the legal advice they gave to justify the invocation of the act. It's eventually going to come out. If it's going to come out eventually in this promised appeal, then let us share this with parliamentarians, let us share this with committee members, let us share this with Canadians, because they have a right to this information, as do we. So, I've gone on long enough. I know other members want to talk, and I don't want to sit here till 9:30. So I'm going to cede my time back to the chair. Thank you very much.
Merci, Monsieur Brock.
Thank you, Mr. Brock.